Welcome to Defending the Windy City with attorney David Drwencke. As the founding partner of DRD Law, David focuses exclusively on criminal defense, bringing courtroom strength, strategic precision, and deep knowledge of evidentiary procedure to every single case. I'm John Lieberman, and today's episode explores a tactic used far too often by prosecutors: overcharging. That is, when the state stacks up more charges than the facts support in order to pressure a plea or gain leverage or something of the like. This is episode 17, when the prosecutor overreaches, fighting inflated charges and overcharging. And it's good to see you again, David. How are you?
I'm great. Thanks for having me again.
Of course. David, let's start with the term itself. What does overcharging mean in a criminal case, and how does it typically show up in Cook County, Illinois prosecutions?
Absolutely. Overcharging, I think you already hit the nail on the head there just in the introduction, is that the state will go for the most serious charge they think they can proceed on. Meaning there could be a number of charges based on how the statutes are written, but they'll go for the highest level charge they at least believe they have probable cause for. And we'll unpack that a little bit later, but it's going for the most serious thing they can rather than perhaps what we all in our heart of hearts, if we could inject them with truth serum, what it really is. And just like you said in the introduction, they do that because then they can scare a defendant into taking a plea or making it seem like they're giving a sweetheart deal where they come off of that serious charge, the one that could include decades potentially of prison time. They'll say, well, you know what? We'll come off of that attempt murder. We'll come off of that more serious gun offense to a more reasonable charge. And then the client, of course, feels more inclined to accept that because they don't want to risk the exposure on the higher level charge. So that's what it is. Overcharging, or again, even if, because there'll be people that bristle at that. If you're coming from the state side or you're a state's attorney or police officer, they're not going to say it's overcharged. It's like, well, a judge or a grand jury allows us to do this. They found probable cause to allow us to go forward with that charge. The response is yeah, probable cause is very easy, a very low threshold. It's like, what do you have that, again, in your heart of hearts, truthfully, that you think you could get across the finish line beyond a reasonable doubt? That's what we should really be talking about, not just where you think you can get it across the finish line for purposes of a preliminary exam or the grand jury.
It's like that old saying, David, that you can indict a ham sandwich, right?
100%. I use that line nearly every day when I'm trying to manage the expectations for a client at a preliminary exam. Allegations are free, very easy, and because the threshold is so low, if I've participated in 1,000 preliminary exams, and maybe we're over that at this point, it's like 99.9% of the time there's going to be a finding of probable cause. And of course, the state tries to make every case sound like a open and shut. It's a slam dunk win for them. It's like, well, why do we keep getting so many not guilties? It's like, well, because it's not as open and shut. It's not as easy as the state would lead you to believe.
In your experience, David, what kinds of charges are most frequently overused or inflated, particularly in felony cases like you handle?
The best example that comes to mind is when they being the state, are attaching great bodily harm, trying to make something an aggravated version of itself. So it's not just a battery, it's an aggravated battery. It's not just a domestic violence charge, it's an aggravated domestic violence charge. So they try to tack things on to make it more serious. And then you come back and realize, oh, they really had some bumps and bruises, if at all. They don't actually meet the threshold for great bodily harm. And the plea comes to what it always should have been, assuming they can prove there was a battery at all. That's the first example. There are others where, again, there's the spirit of the law. There's some sort of maybe a hyper-technical reading where it's like, sure, you can meet the threshold for probable cause on an attempt murder. And a great example that comes to mind was an attempt murder out of the Skokie courthouse where my client, this was all on tape. So it wasn't about whether he was even like guilty or innocent necessarily. It was, what is he guilty of? And it just wasn't an attempt murder. That's what they had brought the charge as, or the top charge as. In a nutshell, he had attempted to steal liquor from a Jewel Osco. He was apprehended by the security guard at the door. He used the liquor bottle and hit the security guard in the head with it and caused serious injuries, not trying to make light of it. and the top charge was an attempt murder. Well, from the moment I read the police report and then later got to watch the video, it's like, okay, it's definitely my client. There's no question of identification. He was apprehended and arrested at the Jewel Osco. We see the incident. He definitely hits him. There's no question about that. It's whether or not this is an attempt murder. And through negotiation and some arm twisting, because the state did not want to come off of the attempt murder. They wanted my client to serve over 20 years on this. But we continued to work. We let them know, it's like, if you're not going to be reasonable, if you're not going to negotiate on what this really is, which is a battery, then we're going to go to trial and you're going to lose. And he's going to be found guilty of what it is he did. But, do you really want to go through this process? They eventually relented and we were able to come to a number. I think the original offer was about 25. They eventually came, which had been served at 85%. So he would have served a vast majority of that sentence. Mm-hmm. They eventually came to a 5-year sentence where he had eaten up most of it on electronic monitoring, and he was more than happy to accept responsibility for what it is he actually did. But that was an example of it. And it took a lot of work. It really did. A lot of negotiation, a lot of mitigation, a lot of being confident in ourselves and our trial ability and understanding the law and the facts to get there. But that's one of the best examples of overcharging. I think less confident attorneys would have actually applied pressure to the client to take a deal rather than fight this out. And I trust that would have involved him spending darn near 20 years in prison. Wow. With many other attorneys, because they didn't want to do the work and they bought into this overcharge and not having confidence.
What role does the judge play in this process? Can the bench push back against prosecutorial overreach, or is that entirely up to you and your team to illuminate what you believe is going on?
At the end of the day, unfortunately, the judge really has very little input on this. Now, I say very little because technically they have none. The judge can't make the state amend a charge. They can't make them do it. Every now and then, if we were to enter into a 402 conference where we're negotiating a potential sentence as to what my client would plead guilty to, I try to see if there may be some pushback by the judge to see if they would apply a little bit of pressure to the state to say, listen, I got to watch the video. I see the aggravation. I see the mitigation. Do you really think this is an attempt murder, just to continue that example? Now, at the end of the day, if the state says, yeah, we do, then the judge can't do anything about it. Can't force them to do it. But the hope is maybe yet another set of eyes, an independent set of eyes at that, not somebody who's pro-defense. It's just another set of eyes looking at this. It's like, hey, listen, the judge doesn't think really thinks this is an attempt murder either. Is that persuasive? Does that move the needle for you to not proceed with this nonsense? That's the hope. But at the end of the day, the judge cannot make the state amend, reduce, change charges, or dismiss a case in and of themselves. They can grant motions to suppress, which can lead to a dismissal as an example. But even then, the judge is not the one who dismisses the case. The state has to do that.
So, David, I know you talk to defendants and their families all day, every day. What do you tell them about what they should be aware of when reviewing a charging document that seems to be stacked or excessive?
Sure. And it's an excellent question, because that's one of the first things that many clients will ask. It's like, I'm facing a class X felony, or my loved one is, or it's a class 1 felony. Those are the two most serious here in Illinois. It's like, is this what I'm going to have to go to trial on? Is this what we're going to talk about and negotiate on? Well, the answer is, if we're going to trial, probably we're going to have to go to trial on that top charge. The state may, in their infinite wisdom, relent and go to a reduced charge or a lesser included, but more likely than not, they're going to go for broke, and we're going to have to fight this out at trial on the most serious charge. Now, about what we may negotiate on, no, that's not necessarily what you'll have to plead guilty to or face the consequences of, because we can negotiate. We can get into those conversations with the state. Perfect example, quite literally from today, is I have a client who's charged with the class X version of gun possession. We'll call armed habitual offender, where somebody with the wrong background is caught with a gun and they face 6 to 30 years in prison for that. It's a class X version. Well, we were able to talk. We looked at his background. Again, on paper, hyper technically, yes, he's appropriately charged, but it's really his first gun offense. His background are other offenses. State, will you work with me here? Like you've got him. Like he is guilty, but guilty of what becomes the question again. And they relented. They came back. They're like, you know what? You're right. 6 to 30 is a little rough. At 85% is a little rough. We'll amend this to just a felon in possession. So it goes from a class X, 6 to 30 at 85%, to a 3 to 7 at 50%. I mean, a night and day categorical difference. And that came from just knowing his background, having the requisite relationship with the state's attorney and so forth, and negotiating. But that's the conversation I'll have with friends and family members or the accused, the client, him or herself, is that, yes, this is what you're facing, but this is also what the state is now being held to proving later on. This is what they have to have evidence of now, and they have to prove it beyond a reasonable doubt. And it goes back to what we talked about earlier in the episode. Allegations are free. Even getting charges are borderline free because it's so easy to have probable cause found. But the real question, what you need to concern yourself with, is what do they have evidence of? What can they prove beyond a reasonable doubt? And if it isn't this top charge, well, then let's go to trial. And then the state eventually will realize they're not going to win. Or if they want to double down, just lose and we'll go to trial and take that not guilty.
That example you just gave was an amazing example. And before we let you go, David, I want to ask you this, because you alluded to this, but it's not as if, because the state is obviously charging in a certain way for whatever reason. And so it's not like you can just go to them on the first conversation and be like, you know what, you're overcharging here. I really want you to give us a little bit more insight into why it's so important to have the right defense attorney with the right background, because you really have to go with your set of facts and all of your background information in order to even get them to the table to start thinking about reducing the charges, right?
Absolutely right. And maybe I'll cut the state a little bit of slack. I may not always like it, and it is frustrating and it's scary for my clients, is the people who do the charging on the front end who approve charges on the front end only know so much. Yes, they've looked at some initial police investigation. They have a basic idea of what witnesses may testify to. And then they look at what the police believe the appropriate charges are. And they'll say, yeah, this on paper, this looks right. Sure, I will approve it. And they're not, again, both the spirit of the law and the facts of the law, they're not even necessarily wrong, but they don't have the benefit of every bit of evidence. Some things are still going out to the Illinois State Police Crime Lab. There's all these background for my client. The gun example that we just went through, again, on paper, technically they're right. He had this charge and he had that charge. This makes you eligible for armed habitual offender. We're going to charge you with the class X. You say, you are right. On paper, you are right. But what you don't know is everything about my client. You don't know the ins and outs of those previous charges. You don't know all of the evidence. You don't know the mitigation I'm going to present. And then, of course, you also don't know who's going to be on the other end of this case. And attorneys do earn reputations. As big as Cook County is, as many lawyers as there are in our county that focus on criminal law, we earn reputations, and those reputations precede us as to whether or not you're the person who applies pressure to your own client to take a deal, or are you applying pressure to the state when their deal is no good on the wrong charge. I'm proud to say, and the reviews bear this out, and former clients would testify themselves, that I'm not going to apply pressure to my client. I certainly will tell them what the upside and the downside is and whether or not I think this is a triable case, but the pressure is applied against the state. They're the ones, they're the other side. They're the adversary. That I'm not on their side. I'm on my client's side, and I'm advocating to get the best result. Sometimes it's a plea agreement on the right charge for the right amount of time or the right program. And other times it's state, prove it. You made an allegation. Great. You've made a bed that you got to live in. You have to prove all of the elements. You have to have the evidence. Let's see in trial. Because I'm not afraid to do that. And the results bear out there that if I'm confident in the lack of evidence, or that the weight isn't there in what evidence they have, or that the state overshot, their problem. That is a state problem. We'll take advantage of the fact that they overcharged in that situation and not let them try to use that leverage, the fear of this real serious sentence, because hang over my client's head that they take a crappy offer that they never should, or let that fear kick in where people are pleading to things that they never did. The pressure is on the state. You want to bring that charge? Prove it.
Great stuff, David. We appreciate your time, and thank you for tuning into Defending the Windy City with David Drwencke. Visit drdlawllc.com to connect with David and his team. And as always, subscribe, share, and leave us a review if you found this episode helpful. Thanks for watching.